Today, we are with one of the leading law firms to discuss the process for the purchase of property in St. Kitts and Nevis.
Hi, I'm Edisha Greene.
And I am Kaela King James.
And we are associate attorneys at Joseph Rowe.
Joseph Rowe is a boutique law firm in the Caribbean with offices in St. Kitts, Nevis, and Grenada. One of our firm's main practice areas is real estate law.
We're excited to guide you through the process of becoming a first-time property owner on the beautiful Twin Island Federation of St. Kitts and Nevis. We shall provide the legal requirements and practical tips to ensure a smooth and successful property acquisition.
Whether you're considering purchasing a second home or an income-earning property, we hope this question and answer segment will provide you with the necessary information to make an informed decision on your next purchase.
What would be the first step in the process to purchase property?
The client will first work with a qualified real estate agent to help them locate suitable property. The client's attorneys will then prepare a purchase and sale agreement for the property, which both the client and the vendor will sign. The purchase and sale agreement contains key terms such as the description of the property, the purchase price, the deposit payable, and the closing. If the purchaser is a non-national of St. Kitts and Nevis, they are required to obtain an alien landholding license. The alien landholding license then becomes a key term in the purchase and sale agreement. It makes the sale conditional on the purchaser obtaining the alien landholding license.
Many viewers may like to know if it is possible to purchase property through a company.
Yes, a company may purchase property in St. Kitts and Nevis. However, if this company is under alien control, meaning its directors and shareholders are non-nationals of St. Kitts and Nevis, the company also requires an alien landholding license to purchase property. These requirements are governed by the Aliens Landholding Regulation Act.
If a foreign client wishes to purchase property in St. Kitts and Nevis, is there any opportunity to do so without obtaining an alien landholding license?
Yes, there is. On reviewing prospective properties with your real estate agent, you should consider that there are designated areas on the island of St. Kitts for which an alien landholding license is not required. One such region is the Frigate Bay Development Area. If, however, a prospective purchaser has decided to proceed with purchasing property in another area which is not exempt, they will require an alien landholding license. Your legal advisor or agent will advise you as to what is required for this application.
Are there any restrictions on who can apply?
There are no restrictions on who can apply for an alien landholding license in St. Kitts and Nevis. Any non-national from any jurisdiction is eligible to apply for an alien landholding license. There are no restrictions on the number of properties that can be purchased or the number of alien landholding licenses that can be acquired.
Please walk us through what a prospective purchaser can expect during the alien landholding license process.
The application form would be submitted, and this application is supported by an affidavit of identity and character. The information which is required for the application is very standard. The applicant will be required to submit their full names, date of birth, occupation, and their address. In the affidavit of identity and character, the applicant certifies under oath that they have no previous criminal record. This affidavit is executed before a notary public. It is important at this stage that the applicant has a copy of their certificate of title or deed to the property, which outlines the legal description of the property. The attorney at law assisting with your application will ensure that all documents are in order before submitting your application to the relevant government department.
Once approval is given, your attorney will engage a surveyor to present 2 survey plans of the lands to the relevant government department. After this, the said government department issues the applicant an alien landholding license, which contains a description of the property and any covenants or restrictions thereon. The license is then submitted to the Inland Revenue Department, where stamp duty becomes payable. The stamp duty payable is 10% of the purchase price of the property, or 10% of the value of the property as assessed by the Inland Revenue Department. Once the stamp duty is paid, the alien landholding license is sent to the High Court Lands Registry for registration. Once the purchase and sale agreement has been executed by the parties, and the purchaser has obtained the alien landholding license, the vendor then executes a memorandum of transfer. The memorandum of transfer is a formal document whereby the vendor transfers ownership from themselves to the purchaser. The memorandum of transfer contains a description of the properties, the names of the parties, the consideration paid for the property, and any restrictive covenants or easements thereon. If the property is subject to restrictive covenants, however, both the vendor and the purchaser are required to sign the memorandum of transfer.
Now, having acquired your property in St Kitts and Nevis, in time, you may decide to sell this property. As the vendor, you will require approval to sell from the relevant government department. The real estate agent assisting with your sale or your attorney can make this request for approval on your behalf. If the potential purchaser is not a citizen of St Kitts and Nevis, they must also qualify for an alien landholding license using the same process we have outlined earlier. You should note that you are permitted to gift the property to your spouse or child. To effect this transfer, you will be required to execute a memorandum of transfer, similar to the memorandum prepared for the vendor to the purchaser transaction. This document will detail the description of the property, parties involved, the consideration, and the effective date of transfer. However, the consideration in this case will not be a payment of money, but the love and affection that the purchaser or transferor holds for the transferee. You are required to also submit this executed memorandum of transfer to the Inland Revenue Department for the payment of stamp duty. In conducting its due diligence checks, the Inland Revenue Department may request a photo ID, being your passport, and your phone number. The Inland Revenue Department may also request permission to access the property. This is done to confirm or verify the value of the property. This memorandum of transfer is also submitted to the land registry for it to be registered. The new certificate of title to the property will be issued to the transferee. If your spouse or child is not a citizen of St Kitts and Nevis, they will require an alien landholding license to hold the property. It is important to note that your original certificate of title should be kept safely. If this title is lost or misplaced, you will be required to apply to the High Court of St Kitts and Nevis to be issued a new certificate of title. A copy of the certificate of title will not be accepted by the land registry to effect a change of legal ownership to the property. You may be wondering whether there are any regulations for the vesting of your real estate property upon your death. If the property was left to a beneficiary in your will, upon your death, your executor will be required to apply to the High Court of St. Kitts and Nevis for a grant of probate to your estate. The executor is not required to be a citizen of St. Kitts and Nevis to be entitled to apply for your grant of probate. It is important to note that this will must be executed in accordance with the laws of St. Kitts and Nevis to be deemed valid. Should you wish to make a will to deal with your property in St. Kitts and Nevis, you should consult with an attorney at law to assist you. If the property is located on the island of St. Kitts, your executor will be required to apply to the St. Kitts High Court versus if the property is situated on the island of Nevis. Then this application will be made to the Nevis High Court. If a property owner dies without having a valid will, the rules of intestacy will apply. The personal representative of such an individual who has died intestate is entitled to a grant of letters of administration to the estate of the deceased. In St. Kitts and Nevis, the rules of intestacy are governed by the Eastern Caribbean Supreme Court Non-Contentious Probate and Administration of Estate Rules, 2017. These rules provide an order of priority for the persons entitled to a grant of letters of administration. This order of priority is as follows: the surviving spouse of the deceased, the children of the deceased, the father and mother of the deceased, brothers and sisters of the deceased of whole blood, brothers and sisters of the deceased of half blood, grandparents, uncles and aunts of whole blood, uncles and aunts of the half blood. Once the representative of the deceased estate has received either the grant of probate or grant of letters of administration, they will be entitled to transfer the property to the beneficiaries of the estate. Any beneficiary who is not a citizen of St. Kitts and Nevis will require an alien landholding license to hold the property.
We hope this video has provided you with useful information about the property purchase process in St Kitts and Nevis.